Okay, the next item on the agenda has to do with possible legislation stemming from the groundwater report. And it's nice to have Bob Marviny back, our state geologist, who did a wonderful job chairing our commission that was charged with looking into groundwater extraction and the impact of international trade on that. And as you will recall, one of the recommendations that came out of that report was the possibility of bringing forward legislation that would require multinational corporations doing business here in Maine to sign an agreement that should disputes arise, they would be settled in our court system as opposed to an international trade tribunal. And we've kind of, we've brought this up from meeting to meeting, and we've kind of not really talked about this. And I believe that cloture is going to be, well, there's a good chance it's going to be in January, so we don't need to make a final decision today, but I think we really do need to start focusing in on this and start having some serious conversations about this and what this might mean.
What legislation might look like with respect to the recommendation in the report that state law might be enacted that would, for purposes of state contracts, require the state to include a provision that would say that any company that entered into a contract with the state would have to waive their right to arbitration, private arbitration under trade treaty claims, and bring them instead in state court or federal court in the state where they're doing business. And that's about the size of the discussion. It's not something that, although it's been discussed by the forum in other states, I believe, and with other commissions, and something that there's some energy for. Last we talked to Bill Ware, and there was no state that actually had drafted anything. So we're out there in front on this, and there are some questions, of course, that will be raised by people, particularly those who object to it. One of the questions that occurred to me is, what if you're an agency that's trying to contract and there's only one vendor out there and the vendor won't sign with this provision in it, then you have a problem. But if you make provision for exceptions, then everybody is going to claim that the exception is necessary for them to enter into a contract. So I think as a matter of making it effective, you wouldn't provide for an exception of that nature. I think that's one of the beauties of state law, is that you just say, if you want to deal with the state, you deal with the state on these terms. We do that in other respects in our procurement process. And one of the other issues that's important to this, I think, is that given the preemption discussion that we had earlier, even the treaty powers that be would recognize that procurement is a peculiarly state process, and so we're offered the opportunity to opt in or opt out on state procurement. So I think that puts this on a sounder legal footing in terms of trying to defend it against challenges. And you really don't need to know at the time that you're contracting whether somebody is or isn't, does or doesn't have investors who might be sitting in some country that could make a claim. It's a matter of saying that if you're going to bring this sort of a claim, you need to bring it in the courts of our country and not in the privacy of arbitration proceedings.
You could write this legislation so it doesn't say this legislation only applies to, multinational, out-of-state, foreign corporations. You would write it to say any corporation that wants to do business with us in this manner will have to comply with these provisions in terms of what court of law applies, which would be U.S. Maine court. In the case of a in-state company, that would be the case no matter what. In the case of a company that was based somewhere else that might be under some, international trade agreement, then in order for that international trade agreement not to apply, they would have to sign a waiver, or at least that would make it clear that they were agreeing to it. So in practice, how this would be applied, I mean, there would be different mechanisms for it, but it would apply equally to any company, would still be having to be under the same law. So I think that, I don't know if that clarifies that, but it isn't, singling out a certain type of company and saying only you, apply this. To say we have an even playing field here, but to make it stick, you need the waiver provision.
I think that the question was, do they sign a waiver, or is it just a matter of state law that this is the case? Mm-hmm. And they do sign a waiver. Everything that relates to contracting process, that's maybe a step I skipped over in my summary, that would become a term of the contract. So you would sign that you agree to that at the time, and you don't, in-state companies, out-of-state companies, everybody signs the same provision. It's not discriminatory. There's no way to tell, I think. You may have a company that you think of as just a Maine-based company, and it might be owned by somebody sitting in anywhere.
Just a quick question. Is there a precedent? Have any other states invoked anything at all like this?
No. There's no precedent. And one of the things that John Delahanty, you all know, who is the lobbyist for Poland Spring, has called to my attention is the report that came out of New Hampshire. They spent about 7 years studying water extraction, and I printed out the 100-page report that John referred me to yesterday, and only read the executive summary. And actually, it's quite nice because their conclusions were the ones that we came to, having studied this for only 6 months. And I'm sure spending considerably less money, but I need to read more carefully. But they didn't take that next step that we discussed in that report in terms of putting the possibility of putting state law in place to try to protect the state against decisions being made in international tribunals. So.
And saying that we're going to remove international trade, any kind of redress, I have yet to hear a compelling argument for why we need to do this. Is it a possibility? Absolutely. I mean, John's question and mine at the beginning, and under a different part of this, was how many times has this actually happened? The answer is once, twice? I mean, yes, there may have been a chilling effect here, but are we really willing to shut out the $148 billion of foreign investment that came into this country last year for the sake that maybe possibly one of our laws might potentially at some point in the future be challenged under an international trade tribunal? I mean, I think it's a terrible overreaction. I think it sends a horrible message to the international business community, and we're not fans. We'll put it that way. I mean, I think that's the simplest way of putting it. This is not just Poland Spring. This is the offshore wind project that we're talking about. This is Montreal, Maine, and Atlantic, which is currently owned by the state. This is the Port Authority. This is everybody. I mean, this is a lot of stuff, and a lot of places that we have potential for good investment that we're essentially going to be saying, we don't want you here. It's one more thing of saying, we don't want you here. If all other 49 states were doing it, I think that would be fine, but I don't want to be an outlier on this. I think that would be chilling. I mean, we used that earlier, but I really do believe that would be chilling. We'll be asking companies to give up rights that they have in 49 other states. I mean, that's suicidal, frankly, in my opinion.
I don't think it sounds so crazy to say if we are using taxpayer dollars on a state contract and then you can't sue us in an international trade tribunal. I don't know. I don't think it's so radical.
I just wanted to clarify from the standpoint of our process, our joint process, the Citizen Trade Policy Commission and the Water Resources Planning Committee, the recommendation that we put forward that was unanimous among those two groups restricted this action to state or governmental contracting. So if you want to represent it as coming from that process, that would have to be the limit.
Thank you.
I would be interested in hearing more from people who know much more about this than I do about kind of how we define procurement, because I know like if the state is contracting services, then are we, is procurement just the things, the literal things we buy, or does procurement also cover what we're buying in terms of services or whatnot? So I would be interested in learning more from you folks about what the difference, where I feel like there's a spectrum of all contracts and just procurement, whatever that limited word means, and so I'd be interested in hearing more about it. Because I think if we have if the state is purchasing services in some way, then we don't want those companies to be able to then turn and challenge our laws.